Second Title Tuesday of 2021. Today we've got Anita Steberg with the Steberg Law Firm, and she's going to talk about titling homes and everything that goes along with it. So Anita, please get us going here. And then again, if you could put your questions in Q&A, we're going to get to everything at the end. That way we can stay on track. So put everything you've got into the Q&A, and we'll get to all the questions at the end. So Anita, welcome.
Perfect. So today we're going to be talking about the legal implications to titling your property. And today I'm going to be talking about the legal implications as well as the tax implications. And let's see if I can get this. There we go. And so as Jody said, and thank you for the lovely introduction, my name is Anita Steberg. I am an attorney in San Jose, California, which is where my firm is located. And we do help people with tax litigation and probate, estate, and trust administration and litigation. And that gives me a really interesting background in real property law, because in tax issues, there's a lot of tax issues that involve real property. Additionally, with probate, estate, and trust administration litigation, there are the main assets of a lot of trust and estates are real property. So you end up into this foray into real property. What I'm going to be sharing with you, and what I hope you learn from it, is what is a chain of ownership and why is it important? I want you to understand how equitable ownership is different than the deeded owner or legal ownership, different ways you can hold title, how title can affect the sale of the home, and what decisions need to be made so that an attorney can help you decide to legally hold title. I first wanted to start off with different ways of holding title. In California, we have 4 to 5 different ones, depending on how you differentiate community property and community property with right to survivorship. There's either 3 to 4, and then that doesn't include any entities, such as putting into a trust, an LLC, a corporation, all of those good things, partnership. So the common ways of holding title is community property or community property with right to survivorship. In order to hold it as community property, you have to be married. It's only married spouses that is available to this. The difference between community property and community property right to survivorship is, with having the right to survivorship, it essentially acts as a joint tenancy, which means that the sole survivor of that community, generally it's the wife that outlives the husband, but it will transfer automatically to that spouse upon the death of the first spouse. Joint tenancy is a co-owned property, and that is a specific type of co-owned property. Unless it says joint tenancy on there or jointly titled, generally it'll say person X and person Y as joint tenants. Unless it's specifically set like that, it is not a joint tenancy. It's just a co-owned property. One of the things about a joint tenancy is the joint tenancy will have a right to survivorship. It passes outside of a trust, it passes outside of a will, it passes outside of a probate proceeding. Whoever is the survivor in the joint tenancy is the one who ends up with the property. For example, if Jody and I own property in joint tenancy and I pass away, Jody will receive that property. It does not matter what I say in the will or what I say in the trust. Jody will end up with that property because it is held in joint tenancy. Under California law, if it just says Jody and I own property in an undivided 50% interest, even though we're co-owners, that's not going to put it into joint tenancy. The default is going to be tenants in common, which means we'll do the same scenario. Jody and I own Blackacre, and I pass away, and it's held as a tenants in common, or it doesn't have anything how we're holding it, and so the default under California is tenants in common. Under that scenario, Jody will retain her 50% interest in the property, and my 50% will be distributed pursuant to my trust or the estate, depending on if I have an estate plan, and if I do have an estate plan, what that says. Now, this gets to be a little more complicated because you can always put property into an entity, and it could be in a trust. It could be into an LLC, it could be in a partnership, it could be in a corporation. All there's tax reasons you never want to put real property in a corporation, but I've seen it done. You can hold it into an LLP. So you can have property deeded in an entity as well. That's a little bit more advanced, but you absolutely can. The most common ways of holding title for married individuals in California is community property or community property with right to survivorship. The most common way to hold property in co-ownership is normally under a tenant and tenancy in common. And that's just because most people do not put as joint tenants. But there's no right or wrong as long as you understand what the legal and tax implications are. The chart I have is actually from Fidelity National Title. I have seen every title company have a chart that talks about common ways of holding title. I just happened to pick up Fidelity National Titles because I did a Google search. That's the first one that came up. But you can call any title company and they generally will have a chart as to common ways of holding title. And that's a great resource and reference to have. Well, let's talk about chain of ownership. And a chain of ownership means that with property, we want it to be a very progressive ownership or very linear ownership. We want it to be person X has the property. It goes from person X to person Y. Person Y gives it to person Z, and so on and so forth. We want it to be very clear who owns the property. We want a very clear line of transfer of ownership, and that way we know that the ownership is being transferred sequentially. In order to obtain title insurance without any exceptions or exemptions, the title company is going to need to make sure that there is a clear chain of ownership or a clear chain of title. It's very important because if on Jody's house, Jody, I'm sorry, I'm picking on you today. On Jody's house, if all of a sudden I record a random deed that says, I, Anita, give this house to my sister, and I wasn't the one that owned the house, it's going to create a chain of title issue. And the reason why, because I can only grant an interest that I have in the property. If Jody did not give me an interest in her property, I have nothing to grant to my sister. So if my sister were to go out and buy title insurance, she likely would not be able to get it. And the reason she wouldn't be able to get it is because I didn't have a good chain of title. This is common. You're like, well, of course, this makes sense. How could this even be an issue? So let me talk about a case that we have in my office right now. We have a person who, husband and wife, who owned property as husband and wife community property. 2004, they created a trust and they put the property, deeded it from themselves individually to themselves as trustee. Very proper. There was no issues with that. 14 years later in 2018, right now we have it held in trust. 14 years later, nobody goes back and looks at what is the last recorded deed. And in 2018, they put together their own deed of trust and or grant deed. And it states that husband and wife as individual grant to themselves as individuals, as well as to their son as joint tenants. Mom and dad pass away, husband and wife pass away, and fast forward to 2021. The issue becomes, is that what grant deed can they, one, is there any title company that will insure it? And two, do they have a chain of title issue? Because remember, in 2004, they owned it as trustees, and that was the last recorded deed. In 2018, they deeded the property in a joint tenant, but they did it as themselves as individuals, not as trustees. In 2018, they had no interest in that property as individuals. So chain of title issues happen, even though everybody that you talk to in a very theoretical sense says, oh my gosh, that could never happen. It happens today. It continues to happen because we have these issues. So it's very important when a title is being transferred, somebody go back, look at how the last recorded deed records the grantee line, that's the person who received the property, and that is exactly the way you want to title it on the new grant deed as for transfer or. Always check to see how the person holds title to ensure that they are consistent when he, she, or they transfer a title. That is so important. It's so easy to resolve a chain of ownership. The problem, especially for property that has been transferred from generation to generation, there could be a cloud on the title, and it's because of the chain of ownership is not there. There has not been a clear line of transfer. And it's possible maybe mom and dad transferred the property to their son while they were living. Maybe there was, like in this case that I was just talking about, it was given to them as trustees. However, when it was time to transfer it to their son, they did it as individual. They gave it to their son. Son gets older, decides that he wants to give it to his adult daughter rather than do an estate plan. He transfers it to his adult daughter, and maybe 20 years from now, his adult daughter decides, hey, I want to sell the property. And during the process of selling that property, a title company does a chain of title report, and they realize, hey, there was a problem 2 sales ago. One, you didn't go through escrow. Everybody did their own DIY. It never went through escrow because it was just transferred between family members. Now we have an issue, and how are we going to clear this up? And who is, the legal question is now, who is the owner of the property since the 2018 deed was not valid? In this case, maybe we have a 2025 deed that when the adult son deeded it to his adult daughter, do we have to go back? So they become very complex very quickly. And before I get into this slide, once again, after I do this, do the presentation, I'm going to open up the Q&A box. So if you have a question as we go, please put it into the Q&A chat, not the chat box, but the Q&A. And after I do the presentation, I will answer questions regarding anything that comes up. The next issue that we see for title is an equitable owner versus a legal owner. A legal owner is very clear. It's who's on title. When I go to the county recorder's record, whose name does appear, who names appears on the title? That is the legal owner. The equitable owner does not necessarily has a deed. So it's not like everybody in the world knows who that owner is like you do with a recorded deed, but they have an interest in the property. Now, a typical scenario under this is perhaps there is somebody wants to buy the property. And let's give him a name. Say Joseph wants to buy the property, but his credit isn't all that great. And so what's going to happen with Joseph? What's going to happen is the doesn't have good enough credit. So he has his father. Joseph's father goes on deed because Joseph Fathers has great credit. He has a reliable source of income. He could qualify for the financing. And the contract or the agreement between Joseph and Joseph's father is, Joseph, this is going to be your property. You are responsible for giving me the money for the down payment. And you're also going to be responsible for all the upkeep. My name is just on there as a convenience only. and I will sign off on the papers and the mortgage, and I'll make sure the house we can get the house. It's going to be in my name only, but you're responsible for absolutely everything. You're responsible for the maintenance. You're responsible for the real property taxes. You're responsible for the mortgage. Anything associated with that property, Joseph, you are going to pay for. That Joseph would be an equitable owner. Joseph's father, whose name is on title, would be the legal owner. So there's a couple of different consequences to this scenario. One is that Joseph's interest in the property is never recorded. So that means that if Joseph's father wanted to, he could sell the property, and he does not necessarily need Joseph's permission. He could get another loan on the property, refinance, take cash out once again, and no one's going to know that Joseph has an interest on that property. It can have federal and real estate tax implications. The federal and state implications come when we have who's going to take the deduction. That can be a federal income issue. Who has to claim the income? Who gets the expenses? Who gets the benefit of the deductions on, for example, on Schedule A for mortgage interest or for real property taxes? The real estate tax implications come in, and what happens when Joseph, even though the agreement is it's always been his property, goes on title? Is that going to trigger a reassessment? And under the current law, it could, depending on how much that property is, and depending on if it's Joseph's father primary residence. If it is Joseph's primary residence, it absolutely can trigger a tax assessment. So if there is this agreement that Joseph's father is going to be on title, but Joseph is not, and this is a verbal agreement, is that the best way to do it? And any attorney will tell you all agreements related to real property should be in writing, and they should be recorded with the county recorder's office. That may, before you do that, that may go against something that's in the contract with the mortgage. It may accelerate the mortgage, but that's something that you want to do. You at least, if it's not recorded, you at least want something in writing, because another scenario is Joseph's father, who's on title, passes away. Joseph's dad has 5 kids. Joseph is just one of them. And one of the kids find out that dad's name's on that property. Joseph's father's name is on that property. And they're going to argue to say that should come into the estate and that should be divided if there's no will or trust, or maybe it's divided equally in a will or trust, but he should get 20% of that property, or it should be sold and it distributed equally between the kids or pursuant to the trust, however that goes. And unless there's documentation to show that it's not Joseph's property, it is, or Joseph's father's property, it's Joseph's property, it's, you end up with a very complicated type of litigation against, because not everybody knows nobody knows about this transaction and this agreement. So how can title issues affect the sale of the home? And I'm going to give you some examples of some what I call title issues. Is somebody working in a fiduciary capacity? For example, mom or dad no longer have the mental capacity and to sign legal documents. So is there a power of attorney? Is there is been deeded into the trust, and the person who is last on title as trustee of the trust is no longer trustee of the trust? Is there a break in the chain of title? What happens if you're unable to locate a co-owner? What happens if there is a personal loan that has been taken out against that property that was done through a private individual, and you lost track of that private individual and they never released their claim on that property or that secured interest? How can all of these things affect the sale of a home? if you've been a real estate agent or if you've been a title officer or escrow officer, you know that these can delay, makes significant delays in closing. Sometimes the fixes are easier, sometimes they are harder. And what I mean by that is sometimes if you just have fiduciary capacity and that person lacks capacity and you're dealing with the power of attorney, and you just need to get the documents to show that that power of attorney is effective and record the power of attorney, that's an easy fix. It'll delay closing, but it won't delay closing the way a court action will. If the issues are significant enough, such as there's a break in the chain of title, the title company is going to be unable to insure that title, or they're going to carve out an exception, which means the new owner is going to take it subject to that default. And that new owner, or the potential new owner, when he meets with counsel to say, I don't understand this, they're going to let him know, hey, this means that there may be somebody out there who has an interest in the property, and that person may come forward at some time. You know, is that really going to make a potential buyer thrilled? No. Is that going to scare some potential buyers? Absolutely. If we need to file court action to clear title, there's absolutely a way to do that. It's not quick. The courts are backlogged. There's a court process for that, but that court process is not going to be you show up the first day and you can explain the position to the judge signs off on it. Normally that is not the case. Your first hearing is not the trial where the judge makes that type of determination in most cases. But it can, in Santa Clara County and San Mateo County and Alameda County, getting a case from the time that you file it, depending on what type of case it is, till it goes to trial for a court to make its decision, that can take a year or two. So it can delay the closing. And then you have a buyer who's telling you, you need to specifically perform, or maybe that the buyer says, I'm not interested in this because the title company has carved out such a huge issue for me. So title issues can absolutely affect the sale of a home. That is one of the reasons why title companies and escrow companies are so important, that they do their due diligence. And it's not because title officers really like to delay sales, but because the title company is going to require due diligence and they are looking for these type of issues. So what are some of the legal consequences over who can, over titling? The first one is who can take the real property deductions? Who can take those real property deductions on their personal income tax return, or who's responsible for filing Schedule E? Who's responsible for claiming any income if it's rental property? These all are determinative in large by how the title is held. Another legal consequence is who inherits the property when the owner passes. We talked about a couple of different scenarios between joint tenancy and tenants in common, and community property versus community property with right of survivorship. And so before you determine how to take real property, you have to understand if somebody passes away, if you hold title this way, this is how it's going to affect the estate. And they may say, well, you know, I want it held in joint tenant, and when I pass away, I want it to go to this person. They have to understand that if you hold it in joint tenancy, you're not going to get to choose through your estate plan who the property goes to. That would have to be reserved in a tenants in common. So joint tenancy probably will not achieve that person's long-term goals. Will the property be reassessed? That always comes up. And what we mean by that is when and will the property be reassessed? Maybe it won't be reassessed right now. Maybe it'll be reassessed at a later date. Will there be a step up in basis when somebody passes away, and who does that step up in basis pass to? And what is the potential liability for all co-owned property? For example, if one of the co-owners gets a divorce, if one of the co-owners let's say, gets $1 million judgment against them because they have perhaps driven drunk and severely damaged somebody, severely injured somebody, whether it's property or a person. What is the liability of all co-owners? And we see this a lot in families who say, instead of doing an estate plan, I am going to put all of my kids on my property. So mom will say, I'll just put all of my kids on the property. And sometimes that's a good idea. I've yet come into where it's a great idea, but some people think it's a good idea. But the problem is if their children get divorced, if there's a judgment against them, if maybe their business owner, the business goes belly up and if they're not in an entity, all of this has exposure for the co-owned property. Or one co-owner allows somebody to come on the property, they are injured. Is it just that one person's interest that can be limited or that can be affected, or is it all the co-owners can be sued for that? So there are legal consequences to how you hold the property. And it is, there we go. And there's also tax implications. And the tax implications are real property tax at the county level, the state income tax level, the federal income tax level, the federal and state estate taxes, which are called death taxes, step up in basis, and reassessment on real property. So those are issues that all of those can be affected by the way that you hold title. We talked about who can take the deductions. That's a federal income and a state income tax issue. We talk about who receives the property at the death. Is it included in that person's estate or their trust? Or does it have to be included on their Form 706, which is their estate tax return? And that's what people refer to as the death taxes. And if they're going to have somebody give the property, is there going to be a reassessment? So there's a tax, not only are there legal implications to the way you hold title, there's also tax implications on the way you hold title. So, and right now I am going to take questions. I actually limited this presentation for a half hour on purpose because I know there's a lot of questions regarding whenever I talk on title. So I wanted to make sure I had sufficient time for question and answer, especially in light of the new laws that started today, because yesterday was a holiday. And so the county recorder's office was closed throughout California. And so we have new laws that are effective today. So I didn't go a lot into Prop 19 and its progeny. Let me give you a disclaimer about Proposition 19. Normally, when legislation is enacted through the normal legislative channels, which means it starts in a committee and then it's proposed and then it makes its way through the legislation, finally ends up on the governor's desk to sign, there's a whole process. And that bill is vetted and vetted and revetted and reworked and reworded. And the final bill, it can be very different from the initial bill. If you are at all interested in the legislative process, it's fascinating, but the final bill can look nothing like what it started as. And for real property issues, especially for reassessments or franchise tax board issues, then we have, after the bill's passed and signed into law, we have a governmental agency, generally, like I said, it's Franchise Tax Board or Board of Equalization, that puts out regulations that interprets what is meant and how things are going to work. Proposition 19 was placed on the ballot and passed. It did not go through all of that vetting. It was written by a group of individuals. And with any type of proposition, especially one that it actually changes the California Constitution, there is some areas that are black and white. There's a lot more areas that there is just not a lot known. And We're not getting a lot of direction from Board of Equalization. Everybody that I've spoken to in Board of Equalization, and Jody, I can see is shaking her head, says that there's going to have to be cleanup language. There's going to be regulations. They're already talking about, I know of at least 2 bills that they're talking about to do cleanup language, to make sure that it is working consistently throughout the counties. Last week, I was on a phone call with Santa Clara County, and I had the same issue in San Mateo County, and we're trying to get clarification on a certain issue. And like I said, one deed had to be recorded in Santa Clara, one deed had to be recorded in San Mateo. Their answers were not consistent. How it's going to work in San Mateo as far as an interpretation regarding one issue is very different than the way Santa Clara County is going to interpret it. When that happens, there's going to be litigation. And we've been told since it passed, there will likely be litigation over at least some of the issues in Prop 19, and it'll be the courts that will interpret what was meant in there. So we still have a lot of uncertainty with Prop 19. Jody, do you want to add anything? I know that you have been, SCORE has been on the front lines with it.
Yeah, you guys will probably have noticed that SCORE, marketing meetings have had people come in and talk about Prop 19, but SCORE, I purposely not, just because, to Anita's point, it's all up for interpretation, and we don't want to start putting things out there and playing guessing games. It's going to be up to Anita and her colleagues and the judges to go forward and try to interpret this. And honestly, if you have questions, consult an attorney, whether it's Anita or somebody else. Talk to an attorney to find out, to make sure that you don't start down a path that you can't come back from.
And if you are a real estate professional, this is always my thing with real estate professionals is, I'm an attorney. I don't, what is that term? Skate outside my lane or something?
Yeah, you stay in your lane. Yeah.
Stay in my lane. And
Yeah.
I know my lane is the legal realm. And when it comes down, when people say, what will the title company do? I say, I'm not the title company.
Let's go ask them.
Let's go ask them. I don't guess to say the title company should do X, Y, and Z, because I need to stay within my lane.
Yeah.
So real estate professionals, I know that you are being looked at, especially with the time that we have a lot of uncertainty about questions. The problem is that if you answer them and you answer them wrong, it's possible you are taking on liability. And if you are giving legal or tax advice, your E&O insurance is not going to cover you. So be very careful that there's a difference between disseminating information and providing legal or tax advice that someone is going to rely on. And to you, you may say, I'm just providing information. The client you're consulting may say, no, you gave me tax advice or legal advice that I then, that I relied upon, and it was erroneous. So be very, very careful anytime that you go through something like that to make sure that you are staying within the confines of giving information, not legal or tax advice. If you have any questions about that, definitely either consult somebody else in your office, preferably the manager. If you work with the larger brokerage, talk to their in-house counsel if you have any concerns about that before you give the advice, preferably. Because they may say, don't do that. So,
and that's a good lead in. Actually, our first question is, how much can a real estate agent say if a buyer asks on how to hold title?
I think that's a great question. Thank you, Stanley. So I would say you can give them the information. I think that you can provide them, like I said, any title company is going to have a chart similar, if not exactly like the one Fidelity has. You can provide that to them. If they have questions and they say, it's a brother and sister, and they say, oh, we want to hold it as community property. I don't think it's outside to say community property is only for married couples. You're not a married couple. You have to choose either joint tenancy or tenants in common. But as far as this one is better for you, I think that's at the time that you are crossing the line or you're going outside of your lane. I know when I do consultations with individuals and we talk about how they should hold title, I'm talking to them about how are you going to use the property? What, is there an agreement that you have with somebody else that says, this is what our agreement is? My scenario before was Joseph and Joseph's father. We talk about what their goals are. Who do they want to, at least at this point, who do they want to end up with the property? Are they going to be transferring it during their lifetime, or are they going to be using it if they have the property at their lifetime? Are they going to leave it to their children or somebody else to inherit? It is a very in-depth consult, so I think it does a disservice to the client to just give a 5-minute answer, or just have a 5-minute conversation. I think you can tell them these are the ways to hold title. You can provide them with the information. I don't think it's the best to advise them which way is best for them.
Yep.
Um,
Let's see. I'm gonna go a little bit out of order than what's on here. What about a single person taken title? Is that on? The person, not sure if that was on the chart.
It's not on the chart. And the reason why is because if you are the only person taking title, you don't have a lot of options. You're going to take it as your separate property, more than likely. If you're married, there's some finagling in there that you could take it as your separate married individual as separate property. But if you're just a single individual, you're not going to get into the joint title issues. You're just essentially, it's going to be a one person tenant in common. You don't need to put tenant in common. You could just say, if it was me, Anita Steberg as her separate property, or Anita Steberg an individual. There's no joint ownership. So that form of ownership comes under tenants in common, but you don't have to specify it for a single ownership.
I just thought of something, and this is not one of the questions, but this just came up recently where someone left like $5 million to their dog. And we've heard of this before, of owners leaving money to the dogs, but can they leave property to the dogs?
Yeah.
Cats, animals? Okay.
You absolutely can do. Those are called pet trusts. And you can absolutely do it. And that house or that property is used for the benefit of the beneficiary. In this case, it's the dog. Yes, in California and many other states, the first time I heard about that, I think was 2008, 2010. And I was like, they did what?
Yeah.
But it is now much more acceptable and much more out there in the open. You absolutely can do a pet trust, and you can generally, there is a person that is a trustee of that pet trust, and that person's job is to care for the animal, and they can use that house or live in that house and use any equity in the house for that dog's benefit. And then generally there's some type of provision that says, and when the dog passes away, any proceeds will go to wherever they want. It can go to the SPCA, it can go to that individual directly to use for whatever he wants or she wants. So yeah, I love trusts because they are highly personalized.
Mhm.
And that is a great example of a highly personalized trust where you say, I want it to go to my fur baby over an individual. And you absolutely can do that in California.
Interesting. Let's see. Will the value of a property be reassessed at the time of the reassessment or the date of the owner's death? Like, when does that reassessment happen?
So I'm going to change the scenario just a little bit because it doesn't change the answer to this. But a lot of people say, I want it held in mom and dad's trust because I don't want the property to go up. Whether you can do that or not, you're supposed to administer the trust in a prompt fashion unless there is a reason to do this. But let's just say that decision's made. And then you go to sell the property, and you're going to have to show at that point, you either need to go through a probate or go through and show the recorder's office and the assessor's office that this person passed away. They will redo the reassessment. They will do a supplemental reassessment dating back to the time of the owner's death. If there is a reassessed interest, they will send out a supplemental bill. You generally, it's not, the property will be reassessed, not at the time of the recording, It is if it's through an inheritance, it is at the date of the owner's death. Even if you're in probate, and it can take a year to 2 years, depending on the complexity, for it to be in probate, because there's a will or there's no will, and then you sell the property, the assessor's office is going to go back to the date of death, always, if it's through an inheritance.
And you just talked about wills and trusts and probate, and I just want to let everybody know, I'll put this in the chat box. Anita will be with us next Tuesday as well, talking about trust, probates, and wills. And we have Athena Kipps that will also talk about estate planning and things like that. So if you have specific questions on those types of things, bring those questions next week to us.
Yeah. I'm looking forward to that because Athena is an estate planner, which
Mhm.
means she creates trusts and wills. And we probably both do administration, so there is a little bit of overlap, but I'm a litigator too. So I deal with issues regarding trusts and estates and family dynamics. So it's always very interesting to get two people who maybe we both work with estate and trust. We likely have two different perspectives.
Yep. So let's see. If we add our children to the title of our home, when we pass away, does the home automatically pass to the children?
Depends on how it's held. And the reason I say that is because if it's in joint tenancy with, say it's you and your children, and it's in joint tenancy, the property will, when you pass away, will automatically transfer to your children. Now there's some estate issues you're not going to, that may come into play, but it will pass automatically to your children. Now, will that mean that the property is not reassessed or what the value is? That's a whole nother ballgame, but it will. Now, if you hold it in tenants in common, that is not the case. If you and your children hold it as tenants in common, or you did not specify joint tenancy, when you pass away, your portion of the property will be distributed pursuant to your estate plan. If you don't have an estate plan, don't worry. The state of California, and its graciousness, and every state has this,
They'll do it for you.
the statute decides what your estate plan is. So, and that is not unique to California. Every state has, it says if this person doesn't have an estate plan, we will provide one. And it's generally goes down by lineage, by blood relation.
And that kind of means that so if, again, you and I, we have a house, and this goes for anything, whether it's any relationship. If I die and the house is $1 million, you get half, because you get to hold $500,000 worth of that house. And then if it's not titled property, that other $500,000 goes to whatever that my estate says.
Correct. And if your estate says it goes to your husband, and your husband and I do not get along, well, guess what? Now we have a property that we co-own together because it was not held as a joint tenancy. So absolutely.
Yeah. So yeah, I think that what I'm learning out of this is make sure it's joint tenancy.
If that's what you want, then maybe there's, like if you and I owe the property together, and it's not our agreement that it should go to, if you pass away, it goes to me, and if I pass away, it goes to you, and you want it to go to your children, do not hold it in joint tenancy.
That's true. Yep. So it's a discussion. I think it's a discussion that maybe people don't think about, and they just take for for granted. Oh, we're married, we're good.
Yep.
So I'm gonna skip a couple of these. How someone can waive their equitable ownership on a property can be a separate agreement if it's not able to do it on the title.
So I think what you are saying, Mike, is that if there is equitable ownership, we're going to go back to Joseph and his father, and Joseph's father is on title, but Joseph is not. And at some point, Joseph says, I'm going to move to Illinois. And Joseph's father says, well, I'd like to keep the property. And Joseph says, fine. Joseph can sign a document that states that he waives any equitable ownership on that property, if that is the intention. Anything with real property should always be done in writing. In California, we have something called statute of frauds that says if it is affecting real property, it should be written. It doesn't have to be recorded, but at least in writing. And he can absolutely have somebody waive their equitable ownership on the property.
And that kind of is that kind of related to the second part of that is, can you record an equitable interest on a property?
Yeah, and the reason, but at that point, you become the legal owner of the property, right? Because if Joseph's father, says, hey, listen, Joseph, your credit is good enough. I want to go out and buy another house, but I need this mortgage off of my property or off of my credit report so it doesn't come into the loan officer's debt to equity financing and expenses and all that. Joseph's father can transfer the property to Joseph. And at that point, Joseph is the owner on title. He is the legal owner of the property. That's how an equitable owner becomes a legal owner. Or maybe they decide that Joseph's father is going to, instead of owning 100%, he is going to give Joseph 50%. Once again, is that subject to reassessment, especially under the current Prop 19? It could be, depending on how Joseph's father is using the property, how Joseph is going to use the property, how much the property is worth. That can be a reassessable event.
And you may know these acronyms, but then Mike is asking, is JT as good as JTWROS?
Yes, so joint tenancy is JT. Joint tenancy with right of survivorship is JTWROS. Joint tenants by right have whoever survives is the one that gets the property. So yes, they're synonymous in California.
Okay. Let's see. An individual inherits a property but does not sell it for 8 to 10 years. Then they want to sell it. When is the step up in basis calculated? The time of death or the current market value when it sells?
The step up, if there is a step up in basis on the property, that is calculated at the time of death. That is never the property when it sells. And a step up in basis is only for federal and state capital gains tax calculation. So it's never calculated when the property sells, even if you hang it on, it doesn't matter if it's 8 years, 10 years, 30 years, 2 years, it is at the time of death. In order to have that step up in basis respected by the IRS for your capital gains calculation, you want to have that property appraised. And even if it's 8 to 10 years that you hang on to the property, like this scenario, the appraiser can always do a date of death valuation. It's going to be, they're going to look back at the property values at that time. So, and that way, when you do your Schedule D for assuming that this is, that it's not held in an entity or nothing complicated. When you do your capital gains calculation, if the IRS contests what you're claiming the basis is, you have something to show the IRS, because the preponderance, because the taxpayer is the one with the burden of proof in any tax case. So you want to make sure it's not, you don't just want a real estate or a broker's opinion or comparable price analysis. That will not stand up to the IRS. You need an appraisal.
Okay. My clients are beneficiaries of a trust. There are 8 of them, sounds messy, who are siblings, sounds even messier. The trust provides that at the time that the successor trustee distributes the property to the beneficiaries, only the surviving beneficiaries will be entitled to receive title. What happens to the heirs of the deceased beneficiaries?
That is a great question. I have had this scenario happen quite a few times, I think 3 or 4 times over the last 5 years that I can come up with. And each time it is different. And the reason why is we have to look at the trust and provide what the trust provides for. Is in order to be determined a surviving beneficiary, some trusts say that the surviving beneficiary just has to survive for 30 or 60 or 90 days. And if they've met that, then they're a surviving beneficiary, even though they're not alive at the time that the distribution occurs. If that comes out, then we also have to look at the trust saying, if the person is not there, does it go to his estate, or does the trust say, if this person is not here, this is who it goes to. So you really have to look at the trust and really have to dig down to what it is. So you have to look at the trust. That is a very, that's a legal analysis to do. And if the trust is unclear, I'll tell you how every trust attorney that I know, we go, in order to protect the trustee from getting upset and getting sued and being in litigation later on, we actually file a petition for instructions, if it's ambiguous, with the court to tell the court, this is what the trust says. It doesn't provide for this scenario. And so we are requesting instructions from the court. This is how we think it plays out. And everybody gets notice of it, including the heirs of deceased beneficiaries. If nobody objects and the court agrees with our analysis, they're going to sign the order. If there is somebody who disagrees, their objection will be heard and the judge will make a determination and give an order, written order by the court to the trustee as to what will happen. And that protects the trustee from future liability. So once again, trusts are very personalized. And I wish I could tell you, Samuel, this is, oh yeah, really quick, easy. This is how you do it. But because trusts can be very personalized, you have to look at the different provisions of the trust to determine what happens.
I was listening to one of my radio shows in the morning, and one of the talk show people said that they specifically wrote in their trust that if anybody objects to it, they're automatically out.
Yeah, and that's called a no contest clause. And under California, if you have reasonable cause to contest the trust, even that clause is not enforceable.
Oh, wow. Okay. Didn't know that. Let's see. My husband and I are helping my brother to purchase a home. This will be my brother's primary residence. I'm going to say not how is it going to be, because it's your choice, but how should title be held among the three of us? What if we have a trust between me and my husband? Can we add this joint property with my brother to our trust?
So yeah, so you can, once again, this is a more in-depth analysis, but as far as you can hold it in joint tenancy with the trust, you can hold it as trustees in joint tenancy with a third individual. The trustees portion will be determined by the trust, or I'm sorry, no, it will not be determined by the trust because you hold it as joint tenant with a third party. So when it's in joint tenancy, the survivors are the one that ends up with the property. You can hold it in trust, but it's going to pass outside of that trust. So when someone says, I'm going to hold it as trustee and we're going to have it as joint tenants, part of me is always like, well, why? What's the thinking and as a litigator, what's the thinking and rationalization behind this? Because it's going to end up with the other person, assuming that they outlive you. If you are the last person, and this is the only value of having the trustees take property as joint tenants, if your brother passes away before you, for you and your husband, when you pass away after your brother, it's going to be distributed pursuant to the trust. And that's the only time, as long as you understand that, it's the only time it really makes sense for you to go on title with trustees. If you die, you and your husband die before your brother dies, assuming that you don't change that title, it does not matter what your will says, what your trust says, your brother is going to inherit that property. So just be aware of that. You have to decide, do you want the property to be part of your estate? Do you want it to go to your brother? Or is this going to be part of your children's inheritance or part of your dog's inheritance or whoever, or, if you're leaving it to charities, is that part of their inheritance? Or are you okay knowing that it can go to your brother? And the answer now may be very different depending on what your life is like than it will be 10 years from now. You can always break a joint tenancy by deeding the property to the three of you as individuals in common, or tenants in common.
I think, and this is something that I recently learned personally with my family, is if you're going to be selling a house, make sure that the sellers can legally sell the house. Not that we were trying to sell an illegal house, but if it's, in a trust, or if you have executors trying to sell a home, I think it's important to make sure that who's ever putting that house up for market can legally do it. We had some issue, not us, but I've heard of issues with LLCs and people thinking they're doing all these things for whatever reason, and it goes to find out you can't legally sell the house.
When I talk to real estate agents, there's generally 3 scenarios that come up under that. And the first one is the person says, mom passed away, but I'm her power of attorney. Well, the power of attorney is only effective while they're alive. Once mom passes away, that power of attorney is ineffective. So if the house is under a trust, it needs to go, the trustee can sell it. If there's no power of attorney, then it goes through her will. And if, like I said, there's a will, if there's no will, then it goes to whoever the state of California says gets it. So that's the first scenario that comes up. Second scenario is, I am the executor of mom's will. Mom passed away. Mom's will has not been probated. The will, in order to give the person the authority to act under that will, has to be appointed by the court. There has to be a filing. The court has to appoint that person. And so they have a will that hasn't been probated yet, and they're trying to sell the house. And of course, title will be very quick to catch it. And they say that there's no order from the court. We can't do anything. The third scenario is, it is a person, like if the house is in a trust, it is somebody other than the current acting trustee to sell the property. For example, it is like my family, I'm one of 7 kids. And, if one of my sisters is the trustee and I'm talk to the real estate agent, I'm like, hell yeah, mom and dad's trust are, they told me that I'm in charge of it and they want the house sold and divided. And I start working with an agent, I have no authority. And so it's very important that if you are working with somebody, the first thing you do when you get that listing agreement, go look at the last recorded title, find out what that is. If that is the name on there is different than the person sitting in front of you, get the document that gives them the authority. Because as a real estate professional, you don't want to waste your time talking with somebody that does not have the authority. And maybe the person who does have the authority is already talking to somebody else. So you're not going to get that. Or maybe the person you're talking to can introduce you with the person with the authority. So those are the 3 scenarios I normally come up with, that the real estate agent is dealing with somebody other than the person who has the authority to sell the house.
Can a beneficiary be outside of the United States?
Under most
That's a good
scenarios,
question.
yeah, absolutely. A couple of years ago, I probated an estate. The beneficiaries were the decedent's sisters, and they lived in England. You absolutely can have somebody outside the US be a beneficiary of a trust or a will.
Okay. How do you get, this might be a loaded question or a longer question, but how does one obtain a power of attorney?
Okay, so let's talk about best practices. Best practice is going to be, if you want it for another individual to you want that individual to call an attorney, meet with that attorney and set it up. You do not want to be involved with it. For example, if it is with your mother, especially if she's older and has dementia and you're the caregiver, do not become involved in that relationship between mom and that attorney, because that can be considered elder abuse. You could be even if you don't do anything wrong, you could be accused of elder abuse. And that will do something to switch, under that scenario, to switch the burden of proof under the evidence code. So if you are trying to get one for somebody else, have them set up an appointment with an estate planning attorney, somebody like Athena, that I'm doing the presentation with, who does these. And she can make sure they have, if all they need is a power of attorney, great. If they need a full estate plan, she can do that, assuming they have the capacity to do so. If you are looking for one for yourself, there are some online that you can have. I will tell you, my office, we do a lot of litigation, people that have done a power of attorney or a trust or a will on their own, or one that they've just downloaded, and there's issues with them. Doesn't mean 100% there's issues, but I have seen issues arise, and then we end up in court to straighten those issues out. I would say go to an estate planner and talk to them about, do you need a power of attorney? If they're using an estate plan, Athena will tell you there's 4 documents that make at least 4 documents, minimum 4 documents that make a comprehensive estate plan. That is your medical power of attorney. It is your financial power of attorney. It is a trust, and it is a will. And there's reasons. Some of these are effective during your lifetime, some of them are not, but that you have all of your bases covered if you get those 4 documents. You just can go to an estate planner. There's a lot of SCORE affiliates that do estate planning. They are absolutely wonderful, but I would definitely recommend you go to an estate planner versus downloading something off the internet, which may or may not even be current under the law.
And they do say that it's never too early to do that. That's one of the things that I have taken from a lot of the webinars that I've sat on. I could do one now. You could set one up when you're 18 or 20, 30, whatever age.
My daughter has an autoimmune disease. Her body attacks her liver, and it's terminal for all purposes. And I sat down with her when she was, I think she was 21 or 22, and we did a full estate plan, even though her life now at 30 looks very different than it did at 21, because in her situation, there's a real possibility that she would need a medical power of attorney. And I wanted her to, and she came to me and she's like, I want you to do one. I said, then we're going to do a full estate plan. And
Yep.
So you're, as long as you're at the age of majority, you can have one.
Mm-hmm. Yep. There's one more question in here about a couple has a trust established and they're buying a new house, but signed the purchase agreement as individuals and not trustees of the trust. Is that okay? Or should they amend the purchase agreement to buy as trustees, or ask their attorney to add the new home to the current trust?
That one's an easy fix. A lot of times, especially if they're getting a financed mortgage, the mortgage company, especially for their, is going to say this needs to be taken in the name of your individual names, not as trustees. If it is their primary residence, they can deed it into their trust. Even under Prop 19, that is not a reassessable event, as long as they're not changing the ownership. All they're doing is changing it from them as individuals into themselves as trustees. And they could go back and add it to their Schedule A of their trust, but as long as it's titled in the trust, you can do that. If it is anything other than your primary residence, and there's a mortgage, you actually need the permission from your mortgage lender in order to do that. Sometimes they'll allow you to do that. Sometimes they want you to pay a couple $100 or a couple $1,000, but it can be done. Sometimes I had a client who did not, the mortgage lender wanted, it's the highest amount I'd ever heard of it. They wanted $20,000 to allow them to title in their trust, and it was investment property. And so what my clients did is we talked about it. They didn't want to pay that. And what we did is we prepared a deed, titling it from them individually into the names to them as trustees, had it notarized. We did not record it. And next year they pay off the property, and at that point they will record it. But this way, if they passed away, they have something that is absolutely can be recorded, and they could take care of it at that point. It gave them kind of the best of both worlds.
That's a good, see, always consult with an attorney.